18 minutes. That's the gap between Judge Sandra Merritt signing a 52-page immunity ruling at 2:44 p.m. Eastern and the White House releasing a prepared statement at 3:02 p.m. Not a response, a prepared statement, written before the ruling landed. Sitting in a communications staffer's outbox, finger on the send button, waiting for the signature. They knew this was coming. They couldn't stop it. And now every legal barrier Trump's team spent 19 months constructing, every immunity argument, every privilege claim, every procedural wall, sits in a federal docket marked void. Here is exactly what that ruling contains. Here is the chain of decisions that made it inevitable. And here is why the next 80 hours will determine whether American courts can enforce their orders against a sitting president, or whether that power turns out to be theoretical. Every document cited here is public record. Every timestamp is verifiable. Go to Pacer, pull docket number 1-25-R-00318-SMR, and read it yourself. What follows is what 52 pages actually say, not what the headlines decided they say. Part 1. The ruling that changed the architecture, page 41. Section 7. Paragraph 2. Presidential immunity, whether grounded in constitutional structure, historical practice, or judicial precedent, does not extend to conduct that constitutes willful, documented, and sustained defiance of binding federal court orders. All immunity claims asserted by the defendant in these proceedings are hereby denied with prejudice. Are, quote, with prejudice. That phrase has a specific legal meaning. It means the ruling cannot be relitigated. The arguments cannot be refiled. The immunity claims don't just lose today. They lose permanently in this court on this record. Not denied pending appeal. Not denied subject to reconsideration. Denied, finished, sealed. Here's what that eliminates in plain English. For 19 months, Trump's legal team built every procedural argument on a single load-bearing claim, that a sitting president possesses some form of immunity from federal judicial proceedings that makes compliance with court orders optional while he holds office. Strip that claim and every motion built on top of it collapses simultaneously. The privilege arguments, the jurisdictional challenges, the delay motions, the separation of powers framework, all of it rested on immunity. Merritt didn't chip away at the edges of that structure. She pulled the foundation. And here's what makes this ruling structurally different from every previous judicial confrontation with executive power. Merritt spent 14 pages, pages 27 through 41, specifically addressing and rejecting every argument Trump's legal team could possibly raise on appeal. She answered the appeal before it was filed. She walked through each immunity theory, cited the case law against it, explained why those cases apply here, and closed the door on each one in sequence. Constitutional law professor Diane Okafor at the University of Michigan, whose published scholarship has consistently argued for robust executive authority and who has publicly criticized this prosecution on procedural grounds, posted a written analysis at 4:17 p.m. Her conclusion, whatever one thinks of the underlying charges, the immunity analysis in pages 27 through 41 is legally meticulous. It will be very difficult to overturn on appeal, second quote. That's an ideological opponent of this ruling calling it legally meticulous. Pay attention to that. Part 2. Rewind. The 19-month ladder that led here, rewind. November 4th, 2023, 11:30 a.m. Eastern. Federal grand jury subpoena issued. Standard format. Seeking financial records connected to an investigation into improper use of a federal trust account administered through the General Services Administration. 14 document categories. Compliance deadline, 21 days. Trump's legal team, lead counsel Victoria Harmon, former federal appellate judge, 2 decades of white-collar defense practice, filed their initial response at 3:58 p.m. the same day. The response was 4 pages long. Its central argument, the subpoena is invalid because a sitting president cannot be compelled to produce documents through a grand jury process while serving in office. No negotiation offered. No partial compliance. No request for a meet and confer to narrow the scope. Total refusal. 1. Merritt rejected the immunity argument 4 days later. Her November 8th order, 8 pages, directed full compliance within the original 21-day window. The 21 days passed. Nothing produced. January 2024. Merritt issued a contempt finding. The formal legal conclusion that Trump's team had willfully defied a binding court order. Harman's team filed an emergency appeal the same afternoon. The appeal went to a 3-judge appellate panel. The panel ruled in 6 days, upheld the contempt finding, rejected the immunity argument, sent the case back to Merritt with instructions to proceed. Harman's team escalated, filed a broader immunity claim, arguing not just subpoena immunity, but comprehensive immunity from all judicial proceedings for sitting presidents across all subject matter, the biggest possible version of the argument. The appellate panel rejected that claim too. 15-page opinion. Unanimous. No dissent. April 2024. Emergency petition to the full appellate court. En banc review, meaning all judges on the circuit, not just a panel of 3. Last stop before the Supreme Court. The full court declined to hear it. No opinion. Just a 1-line order, petition denied. Harman's team filed a certiorari petition, a formal request for Supreme Court review. The court considered it at 2 consecutive conferences and declined both times. No comment, no explanation. The Supreme Court looked at this case twice and walked away. That was the last exit. After the Supreme Court's second declination, in March 2025, the road was clear. Every court in the federal system had rejected the immunity claim. The question wasn't whether courts had authority to proceed. That was settled. The question was what Merritt would do with a president who had now refused to comply with her orders for 16 consecutive months. She answered that question today at 2:44 p.m. Part 3. What 52 pages actually build? Here's what coverage is missing about the length of this order. Federal immunity rulings don't run 52 pages. Standard immunity denials are 8 to 12 pages, enough to establish the legal basis, cite the relevant precedent, issue the ruling. Merritt wrote 52 pages for a reason, and that reason becomes clear by page 6, where she states it explicitly. Given the unprecedented nature of the questions presented and the likelihood of appellate review, this court has endeavored to provide a complete record sufficient to guide reviewing courts at every level. She wrote the appeal brief herself. Not for Trump's lawyers, for the judges who will review her ruling. She constructed an evidentiary and legal record so comprehensive that an appellate court can affirm it without a hearing. She pre-answered every challenge. She pre-cited every counter-precedent. She pre-closed every door. Pages 1 through 11, factual record of non-compliance. Every missed deadline, every rejected filing, every contempt finding, time-stamped and docket referenced. Pages 12 through 26, historical analysis of presidential immunity doctrine. Every case where immunity was argued, every case where it was granted, every case where it was denied, side by side. Pages 27 through 41, systematic demolition of each immunity theory. Trump's team advanced, not a summary, a detailed legal argument against each one, with citations. Pages 42 through 48, the ruling itself. Immunity denied with prejudice, compliance deadline set, enforcement mechanism authorized. Pages 49 through 52, what happens next? Step by step, if compliance occurs, this is the process. If compliance doesn't occur, this is the enforcement sequence. Self-executing provisions, automatic triggers, no additional hearing required for any of it. She didn't write a ruling, she built a courthouse. Every room is locked from the inside. Part 4. The compliance deadline and what Merritt put inside it, page 48. Section 9. The compliance deadline. Trump's team has until Monday at 5 p.m. Eastern to produce the financial records originally requested in November 2023. Full production. All 14 document categories. No redactions without a specific privilege log submitted simultaneously. That deadline is not negotiable. Merritt wrote that explicitly. Page 48, line 12. This court will not entertain motions to extend the compliance deadline. The time for extensions has passed. But here's what nobody is reporting about, pages 49 through 52. Merritt didn't just set a deadline. She pre-programmed what happens if it's missed. 4 automatic enforcement triggers, each one activating the next without any additional court action required. First trigger, if no production by Monday 5 p.m., the U.S. Marshals Service Enforcement Authorization activates immediately. No additional order required. The authorization is already signed, already in the docket, already transmitted to the Marshal's Service Director. Second trigger, if Marshal's enforcement is obstructed by any executive branch official or agency, Merritt's order directs referral to the D.C. Circuit's Emergency Judicial Council, a body that can sanction judges and federal officials within 2 hours of obstruction being documented. The third trigger, if the Judicial Council referral is not acted upon within 24 hours, the order directs notification to the Congressional Oversight Committees specified in 28 U.S.C. Section 530D, the statute requiring executive branch notification to Congress of any refusal to enforce federal law. Fourth trigger, automatic escalation to the Supreme Court emergency docket, with a pre-filed application already sitting in Merritt's clerk's office, sealed, ready to transmit. Not reactive, pre-positioned. Merritt built an enforcement chain that doesn't require her to do anything else after Monday at 5:01 p.m. It runs itself. Part 5. The public statement versus the legal filing 3:02 p.m. Eastern. White House statement. Public. Quoted on every network within minutes. This ruling is a weaponization of the judicial system against a duly elected president. The administration will pursue every available legal remedy and will not be intimidated by activist judges operating outside their constitutional authority. Strong language, clear defiance, maximum political theater. 4:31 p.m. Eastern. Harman's emergency motion, filed in the same docket. Docket entry 125-00318 SMR document 247, not quoted anywhere. The motion makes two narrow procedural requests. First, a 72-hour extension of the compliance deadline to permit preparation of a privilege log. Second, clarification on whether certain categories of documents can be withheld pending a separate privilege determination. Read those requests carefully. The White House statement says the administration will not comply and will not be intimidated. The legal filing asks for 3 more days and clarification on redaction procedures. Not X, not Y, not a unified strategy communicating the same message. 2 completely different positions, filed within 89 minutes of each other by people operating from incompatible assessments of the legal reality. The public statement is written for an audience that doesn't read federal dockets. The legal filing is written for a judge who reads nothing else. That gap is the tell. When a legal team files compliance-adjacent motions asking for extensions and privilege clarification, while their client releases defiance-framed public statements, it means the attorneys understand they are losing. They are trying to negotiate an exit from a position their client is publicly refusing to acknowledge is untenable. Harman asked for more time. That's not what you do when you have legal arguments left. That's what you do when you don't. Part 6. The case that has no historical parallel. Here's where the Nixon and Clinton comparisons fall apart, and they do fall apart completely. Nixon faced the subpoena for the White House tapes in 1974. The Supreme Court ruled unanimously in United States v. Nixon that executive privilege, while real, does not override a specific need for evidence in a criminal proceeding. Nixon complied. He handed over the tapes. The system worked because Nixon, facing that ruling, chose compliance over confrontation. The courts were never required to enforce against a non-compliant president. The enforcement mechanism was never tested. Nixon's compliance meant the question of what happens when a president refuses never received an answer. Clinton faced court proceedings throughout his impeachment. He testified under oath. He produced documents. He fought politically and legally, but within the system. He never defied a court order and forced enforcement. Again, the enforcement question was never answered. Here's what's different about Monday at 5 p.m. For the first time in the 236-year history of this republic, a federal court has set a specific, non-extendable compliance deadline for a sitting president, after stripping every immunity argument protecting him, with pre-authorized, self-executing enforcement mechanisms that activate automatically if the deadline passes. Nixon's situation never reached this point. Clinton's never came close. This is the test that the constitutional framers designed the system to handle, but that no president has ever actually forced. Not a theoretical question about the balance of powers. A Monday deadline, a clock, an answer. Part 7. What this means for people who have never set foot in a federal court. Here's where this story reaches into your life directly. The American legal system operates on a foundational principle that most people absorb without thinking about it. Court orders are enforceable. When a court tells someone to do something, the assumption, built into every contract, every business relationship, every property transaction, is that the order carries real force, that it can be compelled, that it will be compelled. That assumption is what makes the legal system functional for ordinary people. When you sign a lease, both parties assume a court can enforce it. When a business dispute goes to arbitration or litigation, both parties assume the outcome carries weight. When a family court issues a custody order, both parties assume consequences exist for non-compliance. Every one of those assumptions traces back to the same underlying premise, that no one is above enforcement. If a sitting president can sustain 19 months of documented non-compliance with federal court orders, with contempt findings, appellate rejections, and Supreme Court declinations, and still avoid enforcement through sheer institutional weight, the premise fractures. Not just for presidents. For every powerful entity that calculates whether compliance with court orders is worth the trouble. Courts don't have standing armies. They have credibility. And credibility depends entirely on consistent enforcement, especially at the highest levels of power, where defiance is most visible and most imitated. Monday at 5 p.m. is not just about these specific documents. Monday is about whether the premise holds. Part 8. The defense has arguments. Here's where they actually land. Intellectual honesty requires this section, because Harmon's team isn't operating without any legal ground to stand on. The strongest argument, Merritt's self-executing enforcement provisions, particularly the automatic escalation triggers in pages 49 through 52, are legally novel and potentially beyond the authority of a single district court judge. Federal enforcement procedures have established channels. A district court judge creating parallel enforcement mechanisms outside those channels could itself be challenged as a jurisdictional overreach. Former federal appellate judge Thomas Brin, writing in the Federal Courts Law Review in 2022, argued that unilateral enforcement innovations by district judges, however well-intentioned, carry serious separation of powers implications. That argument is real. It's the strongest card Harmon holds. The second argument, the with prejudice denial of immunity claims on this record, doesn't necessarily bind other courts or other proceedings. Prejudice operates within a specific case and court. Harmon could argue that future immunity claims in different legal contexts remain open. Merritt's 52 pages are authoritative here, but their binding effect beyond this docket is a genuinely unsettled question. Where those arguments stop, they don't address the underlying 19-month record of non-compliance. They don't challenge the contempt findings. They don't dispute that every court to examine the immunity claims rejected them. They're arguments about remedy and procedure, not about the fundamental legal question of whether Trump has complied with court orders, because the record on that is unambiguous. Harmon can argue about how Merritt structured the enforcement. She cannot argue about whether the underlying orders were defied. That distinction is why the 52-page ruling is built the way it is. Merritt anticipated procedural challenges to enforcement mechanisms and built redundancy into each one. Challenge the first trigger, the second activates. Challenge the second, the third runs. The architecture doesn't depend on any single mechanism surviving appeal. That's a fortress with 4 walls. Part 9, 3 tracks, 1 deadline. 3 separate institutional processes now converge on Monday at 5 p.m. Eastern. Track 1, the judicial clock. Merritt's compliance deadline. Self-executing enforcement triggers. Pre-filed Supreme Court application sitting sealed in her clerk's office. The clock started when she signed the order at 2:44 p.m. today. It runs continuously. It does not pause for appeals. It does not pause for congressional deliberation. It does not pause for weekend news cycles. Monday, 5 p.m. Whatever happens at that moment, compliance or non-compliance, activates the next phase automatically. Track 2, the congressional track. The House Judiciary Committee called an emergency session for Saturday morning. The agenda, confirmed by the committee's communications director at 5:14 p.m. today, consideration of impeachment articles based on contempt of federal court orders and obstruction of judicial process. Saturday's session doesn't produce a full House vote. It produces a committee recommendation. But if that recommendation comes out of Saturday's session, The full House floor vote could be scheduled as early as Wednesday. Watch Saturday's session time. If it runs past noon, a resolution is still being negotiated. If it wraps before 10 a.m., the votes are already counted and the outcome is known. Track 3. The executive branch fracture. The Attorney General issued a statement at 4:47 p.m. today. 14 words. The Department of Justice is reviewing Judge Merritt's ruling and will respond in due course. In due course. Not we will comply with the court's order. Not we will enforce the court's authorized mechanisms. In due course. That's not compliance language. That's evasion language. And the Attorney General controls the U.S. Marshals Service, the agency Merritt authorized as her primary enforcement mechanism. If the Attorney General directs the Marshals to stand down, Merritt's first enforcement trigger breaks. The second trigger, referral to the Circuit Judicial Council, requires the Judicial Council to act within 24 hours. If they don't, the third trigger activates congressional notification. And the fourth trigger, the pre-filed Supreme Court application, runs on its own. The enforcement chain is designed to work around an obstruction at any single point. But obstruction at the first point tells you everything about the administration's chosen posture. Watch the Attorney General before Sunday midnight. Where the clock stands today, 2:44 p.m., Merritt signs 52-page immunity ruling. Compliance deadline set for Monday 5 p.m. Self-executing enforcement triggers pre-authorized. Today, 3:02 p.m., White House issues prepared statement. Defiance language. Pre-written. Today, 4:31 p.m., Harman files emergency motion requesting 72-hour extension and privilege clarification. Compliance adjacent. The tell. Today, 4:47 p.m., Attorney General issues 14-word statement. No compliance commitment. No enforcement commitment. Silence where answers belong. Today, 5:14 p.m., House Judiciary Committee confirms Saturday emergency session on impeachment articles. Saturday morning, committee session. Watch the duration. Watch the outcome. If impeachment articles advance, the political calculus for every Republican who went silent today changes overnight. Sunday, Harman's team expected to file emergency Supreme Court application. The court can grant or deny an emergency stay. Based on the record, 2 prior declinations to hear this case, the likely outcome is denial. But if a single justice grants a temporary administrative hold, Monday's deadline shifts. Sunday midnight, watch the Attorney General. Any directive to the Marshals Service before Monday morning tells you whether enforcement is real or ceremonial. Monday, 5 p.m. Eastern, compliance deadline, the moment every track converges. What remains unknown right now, whether Harman's extension motion gets a ruling before Monday, what Saturday's committee session produces, and whether the Attorney General makes a public enforcement commitment or maintains deliberate silence. The silence is the most important variable. Because when an administration's attorneys file compliance-seeking motions and the administration's public communications office releases defiance statements and the cabinet officer controlling enforcement says nothing at all, those 3 signals are not pointing in the same direction. They're pointing at a decision that hasn't been made yet, or one that's been made and not announced. Monday at 5:01 p.m., we find out which. Subscribe, turn on notifications. Because when that deadline hits, when the docket updates or it doesn't, you need someone who has read every page of every filing in this case to tell you what the next document actually means. Not the statement, not the spin, the document. The clock is at 80 hours and counting.